During trial, the judge has told me I cannot talk about this particular topic. I tried doing it with a particular witness, and the opposing lawyer jumped up out of his seat like somebody pressed an ejection button, yelled out, "Objection, Judge! Mr. Oginski knows he's not supposed to talk about that." And what does the judge say? And what happens if I continue to try and talk about it? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, I'll tell you what can happen. The judge can start yelling at me. The judge can start screaming at me. The judge can make me look silly and foolish in front of the jury. And that's something I never want to happen. I don't want the judge against me, and I don't want the jury to see that the judge is against me or that I'm doing something where the judge specifically told me not to do that. You know, I just want you to see something right here in the background. Let's see if I can get that. Look at that sign. Go for tortoise crossing. How do you like that? You don't see that too often. Okay, so come join me on this walk through the neighborhood as I share with you exactly what happened and what I'm talking about. During the course of a trial, sometimes there are instances where we want to get some information or some evidence in front of the jury. And now there may be a technical legal reason why the defense attorney does not want that information in front of the jury. Or maybe the defense wants to get certain information in front of the jury and we think it's inappropriate. And now we're trying to do everything possible to keep that information out of the jury. And let me give you an example. Let's say this is a medical malpractice case. And now there's something in our client's emergency room record to suggest that she was drunk, that she had an excessive amount of alcohol before she got to the emergency room. And that had nothing whatsoever to do with the claims that we are raising in this particular case. Now, in some instances, that information about the fact that she was totally intoxicated may have a bearing on what the doctors did, at least understanding from a historical standpoint what brought her to the hospital. What was she doing before? What medical issues did she have? And in some cases, now it's critically important for the doctors to learn about and to understand her medical history upon reaching the emergency room. There are other instances, however, where some information like that has no bearing whatsoever and has no relationship or relevance to the actual claims we are raising or to the defenses that the doctor and the hospital are making. In that instance, we might ask the judge before the trial begins to keep out certain information. That's known as a motion in limine. And no, it has nothing to do with lemon, and it sounds similar. Lemon, limine. It has nothing whatsoever to do with anything involving lemons. It's just a fancy way to say, Judge, we need you to make a ruling to take action on something that we anticipate happening coming up during the course of trial. We know that the medical records indicate that our client was visibly intoxicated and had a 1.6 blood alcohol level. Okay. But at the same time, we also know that it has nothing to do with the issues involved in the care and treatment rendered to this patient, has nothing to do with the defenses raised, and we are asking the court to make a ruling to keep this information out because we think if the defense, and we know and we expect that the defense will do everything they can to bring this out to show that our client, this injured patient, was totally intoxicated, inebriated, way over the blood alcohol limit for what would be considered normal, and they're doing it for a particular reason. And now we would argue that getting that information out in front of the jury would be highly, highly prejudicial and have no probative effect, meaning it'll have no useful information or impact upon the jury when evaluating the issues that are really in front of them. Then the judge will have to make a decision. The judge will have to analyze the legal issues, listen to our arguments, read the legal briefs that we submit and the legal briefs in opposition, and then come to a decision about whether or not he agrees with us or whether he does not agree with us. Now, let's say that the judge does agree with us and says, you know what, counselor, you're right. There is no reason for this information to come in. Yes, it's a detriment, the fact that she was totally intoxicated. Yes, she should not have been that intoxicated, but so what? It's got nothing to do with the key issues in this case and the failure to diagnose and the failure to do things properly during the course of surgery. We understand that. So, Mr. Defense Attorney, under no circumstance can you talk about this topic. Now, that means that the defense lawyer is prevented from ever talking about this during any witness examination with any witness during the course of trial. What happens, though, What happens if this defense witness tries to sneak in this information when he's questioning a particular witness, when he's questioning one of the doctors at the hospital, when he's questioning our expert? I'll tell you what happens. Now, I will have to jump up out of my seat, yell out, "Objection, Judge!" Mr. Jones knows full well he's not permitted to talk about this topic. That's totally improper based upon your prior ruling, Judge. I ask that you admonish him and give an instruction to the jury explaining why you are admonishing him. And now, what's likely to happen? What's likely to happen is that the judge is going to agree. Why? Because he made a prior ruling after fully analyzing the issue, coming to a legal decision during an order that he expects both attorneys to abide by. And now, if one attorney is failing to abide by that order, I have every right to stand up and make an objection. What happens in this instance where the jury now hears for the very first time that my client was intoxicated, was inebriated, was way over the legal limit? Well, guess what? Now, the judge is likely going to admonish the attorney for doing something he never should have done. And now he's got to give the jury an instruction because they are likely confused. Why are the attorneys arguing about this? Yes, this is highly shocking that this patient now came into the emergency room with this level of alcohol in her system. Now, could that sway the jury? Could it affect the outcome? The answer is it certainly could. There are many instances where this could occur and it could affect their ultimate outcome. So the judge would be obliged to now tell the jury, listen, ladies and gentlemen, that is something that I have ruled not applicable to this case. You are to disregard this question, you are to disregard the answer, and the fact that she was intoxicated at the time she came into the emergency room should have no bearing whatsoever on your decision and deliberations in this case. Now that's known as a curative instruction to the jury to try and remedy the fact that they should not have heard any of this information. But now let's go back again. Let's say the defense lawyer is not satisfied with what just happened. He still wants to get this information in. He still wants to go ahead and point out to the jury that my client was intoxicated, that somehow her intoxication had something to do with causing her own injuries, and that had it not been for intoxication, she never would have wound up in the emergency room and never would have been under the care of this doctor, and these series of events never would have occurred. What happens now if, during another witness or during another discussion with a witness on the stand, he tries to get this information out again? And now it comes out again. What choice do I have as the opposing lawyer? The only option I have is to voice my objection, to alert the judge that this guy is playing games and he doesn't get it, and he doesn't understand the fact that he is now violating the court's order, not once, but now twice. I jump up out of my seat and with venom, I say, "Judge, objection! This attorney is doing it again." He knows full well that you rendered a prior order telling him he could not do this or bring this information up. I ask that you now admonish him again and sanction him for his improper conduct. And now give the jury another curative instruction. And in that instance, it is highly likely that the judge is going to admonish the attorney again in front of the jury, give the judge his full wrath, knowing full well what his ruling was in the past, and let the jury understand that this is totally inappropriate. There are some instances where a judge will take it further and sanction an attorney for behavior that clearly is inappropriate, where the attorney knows full well he should not be talking about a particular subject and keeps trying to bring it up over and over and over again. The judge will have no choice but to take extreme action and can actually fine and sanction the lawyer for his conduct. That is totally inappropriate because every time he tries to do that, now it becomes obvious that this is not a simple mistake, an innocent mistake where he just mentions it off the top of his head or the witness blurts it out. Instead, this is an intentional mistake, something he intends to get out to try and sway the jury in his favor. And the judge, in all likelihood, is not going to tolerate that type of behavior. So why do I share this quick information with you? I share it with you just to open your eyes and help you realize and help you understand what really happens in these medical malpractice cases in New York. You know, I understand you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but you're thinking of doing so, and you have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.